bring the appeal of Lendore and another, and Bullock and others, against the Attorney General of Trinidad and Tobago.
Yes.
My Lord, I appear in this matter of my learned friend Mr. Gregory Delzin of the Trinidad Bar, my learned friend Ruth Brander, and my learned friend Amanda Cliff Matthews, and the Attorney General is represented by my learned friend Peter Knox of Queen's Counsel and my learned friend Mr. Nabja Atwell. My Lords, firstly, I apologise for the length of the speaking note and for the additional materials. I've apologised to my learned friend. Some of them were in discharge of our duty to the court to make sure that all the materials that were relevant were before the court. And some of them are simply because they're mentioned, for example, in the case of CPSAD, and so we thought the court might wish to have them all. But essentially, I can develop the points mainly by reference to the authorities which were already before the court. The Cord case may be important, which was not before in the original bundle. My Lord, that's the position. I understand there's been correspondence, unless the board.
Well, what does Mr. Knox want to say about the position? Mr. Knox is absolutely to you. We've seen the correspondence.
My Lords, our position is this. We don't want to be obstructive, but there has been, I would say at least this, a radical shift in emphasis in the latest speaking note. It does cause prejudice in the preparation of the case. Not only that, it does, I submit, put us at what you might call a forensic disadvantage, because it means you've actually got a written case, a new written case, to which you haven't got our written case in reply. Mm-hmm. So what I would say, first of all, is we would like the opportunity, if so advised, to put in, after the hearing, a written case or supplement in order to deal with the written points made in the speaking note. That's the first point. The second point is, I'm not due to start today anyway, but I would be reluctant to start today, even if that were on the cards, because I would like to get my head round all this new material. We've obviously had an opportunity yesterday, but it was only yesterday at lunchtime that I actually saw any of this material. And I would like the opportunity to discuss matters with Mr. Atwell this evening, and indeed, so far as necessary, to take instructions on some of the points that have been raised.
Well, are you confident you will be able to do that?
Sorry?
Are you confident that you will be able to do those two things?
Well, certainly discuss
because
with Mr. Atwell.
This is such an important case, unless you felt that you were going to be able to discharge your role satisfactorily, a more radical decision might need to be taken by the board.
Well, my Lords, perhaps I can best put it this way. I'm happy for Mr. Fitzgerald to develop his points. The extent to which I will need to take instructions is not entirely clear to me, I must admit. But it may be that things will come up in argument, which mean I would want to, and would be prejudiced in doing so. If that is the case, then, my Lords, obviously I will have to make my submissions tomorrow, subject to any further instructions we obtain.
Right. But at the moment, you're content to go ahead.
My Lords, at the moment I'm content to go ahead. It would be unsatisfactory, I think, on a case of such importance, simply to, as it were, adjourn it, which really wouldn't be unthinkable. And all Mr. Fitzgerald should feel, well, there were some points of great importance.
We make it clear, I think we've already implied that we're very much in your hands on this, because it seems to us that you have every cause to complain, and the prejudice is something that you're a better place to assess than we are. It's quite an exercise to even to compare the two documents which we've received.
Yes. Well,
anyway, we've got your attitude.
Yep.
Thank you. Mr. Fitzgerald,
I apologise.
No, it's simply not good enough, Mr. Fitzgerald. In every case, we expect to receive from you a speaking note. I have mentioned on a previous occasion that it's not a very helpful procedure to reproduce a different formulation, or to produce a different formulation, but the present is a particularly striking example of the problems that arise. We really have two documents which, as far as one can see, cover to a considerable extent the same areas, but also have a lot of new material relied on, sometimes in relation to the same point. It's difficult to digest them. It duplicates effort on all round, and it's not what written cases to the board or to the Supreme Court are supposed to achieve. They are supposed to be considered documents which represent the basis on which you're opening an appeal. So could you remember that in future? Obviously, it's difficult in a case of this nature, I strongly suspect, to do anything relevant, even in terms of costs, by way of sanction, but it seems to me quite apparent that you can't have two written cases if one were speaking in terms of costs, insofar as that's relevant, it'll be considered in due course.
Yes, my Lord, well, could I deal with that point at a later stage? I obviously apologise to the board. I hope that the board will see when I develop the points that these are simply amplifications and refinements in response to partly in response to my learned friend's arguments. But my Lord...
But then the way to deal with it is by a simple reply, which we frequently receive. This is a completely fresh presentation of the case. That's the point. Anyway, we don't want to make too much of this, but it is a quite important point from the point of view of administering justice in a sensible way.
My Lord.
You had better know, Mr. Fitzgerald, just as a matter of practicalities, that some of us at least haven't read it, for the very good reason that they left yesterday in the confident belief that they had this case sorted.
Right.
A speaking note, if it's simply a way of, if it's simply something to have open whilst counsel is speaking, is fine.
Yes.
But a new skeleton argument causes a different approach. You need to know that I, at least, haven't read it.
I'm obliged, my Lord. Well, my Lord, I hope I've tried to refer everywhere where the case... There is just one point, my Lord, where there is a difference. Apart from that, it's the same basic points, but we've tried to amplify them, as I will speak to it.
Right. Well,
and my Lord, it is, because, as your Lordship observed, this is a very important case, it is in an effort to speed things up so that I won't repeat things, but I apologise.
let us do that.
I do apologise. I apologise.
The excavation is deep enough, Mr. Fitzgerald.
Okay.
I have read it, but I've left it upstairs in my room.
Oh, I think we may have a spare.
To have a spare copy.
I'm very grateful to my Lord for that loan assistance. Can we have well, as your Lordships know, there were two sets of commutations which have given rise to the injustice which the Court of Appeal found in these cases. And we've set them out in the background facts at page 1. But can I just summarise the position? The first set of commutations was in 1993, when the death sentence of 47 prisoners were commuted because they'd all served more than 5 years. Yeah. Laid down in Pratt. So all the more than 5 years cases were in the 1993.
That was a Pratt.
Yes. And those 47 prisoners, all alike, had their death sentences commuted to terms of imprisonment for natural life. They were given no opportunity to make representations, and 8 of the appellants before the board fall into that category. The second set was in April of 1998, and that was in 2 batches of 12 and 7. 3 of the appellants, and they're dealt with at 1.2, that's Ramphry, Lendore and Ram, fall into that category. It's important that they were the 1998 batch. Yes. And my Lord, just to summarise the position, of course, again, in their case, all alike were commuted to 75 years, yes. And they too had no opportunity to make representations. Now, just summarising the position as at 1.1, Pratt and Morgan laid down that if it was more than 5 years, it would be, I think we can put it this way, presumptively cruel and unusual. And, my Lord, I can take the court very shortly to that. Pratt and Morgan at
probably
We would know-
know that.
no.
Yeah, all right,
I
my
think.
lord. Yeah, so that's presumptively.
I mean, if it's relevant, Henfield is perhaps something
Yes.
we're not so familiar with.
Yes.
Is it the position that if you don't have an appeal to an international body, then 3.5 years?
That's my lord. That's in essence it, and that's why we've given you the references there. Henfield says 3.5 years was held to be an inordinate amount of time for the completion of the criminal.
I can understand that. Does it make it cruel and inhuman, or inhuman and degrading punishment or treatment? Though, if there's just 3.5 years without an international.
That was the finding in can I just take you? It's Henfield is at volume 2, tab 22, and your lordships will see that we've given you the reference there, 425B. So, my lord, 425B, however, taking all the relevant considerations into, that's at 1643, all the relevant considerations to account, they are satisfied that in the context of a legal system in which the target periods for appeals is 2 years, and that was the 2 years laid down in Pratt and Morgan, the lapse of an overall period of time of 3.5 years following sentence of death is indeed an inordinate time, and so cruel and unusual. And that's where there's no international appeals. And now, of course, in this case, they stepped in because at a time where, in fact, those free appellants had not completed the judicial process. That's to say, they still had appeals pending to the Privy Council. Pratt indicates 2 years to conclude the appellate process, including the Privy Council. And in those cases, they were well over that, and they hadn't even got to the Privy Council. So it was presumptively cruel to execute. And that was the reason for the commutation. In fact, the 2-year target is actually recited in the commutation advice. That's at page 124. So they actually cite the target. And so at 124, they set out in the record, volume 124, the aim should be to hear a capital case within 12 months of conviction. It should be possible to complete the entire domestic appeal process within approximately 2 years. And then in any case in which execution take place more than 5 years after the sentence, there will be strong grounds for believing the delay is such as to constitute inhuman or degrading punishment. And then one sees set out there in that minute that they recommend the commutation. And the commutation included people, as I say, 1 4 years, 10 months, 1 4 years, 4 months, and then and in the later commutation, 3 years and 9 months. So, my lords, can I just give you one further reference, and this is in volume 9, because the board may wish to see that the Caribbean Court of Justice has applied Pratt and upheld it. That's to say, the replacement court for the Privy Council.
This is Thomas and Baptiste.
No, this is Boyce and Joseph, my lord.
Boyce and Joseph, I meant.
Where is it?
It's volume 9, my lord.
9?
Yeah, volume 9. Yes, it's been handed. Yes, your lordship should.
But has given us a slightly different rationale of
Your
expectations.
Yeah, exactly, my lord. Yes, but not in relation to the cruel and unusual.
No.
That's got McLaughlin, which my lords indicated it would be helpful to have, and we've also put Hutchinson in because that followed on from Hutchinson number 2 followed on from McLaughlin. But my lords, if one looks at paragraph page 393 to 4 there, 393 to 4 of volume 9, my lord.
Tab 9, is it, or volume 9? No, volume 9, yes.
Yes, volume 9, yeah. Tab 14.
Yeah.
Does the board have, this is the judgment of Chief Justice de la Bastide and Justice of Appeals Saunders.
Right.
And one sees at paragraph 45, Pratt is cited, and then can I just take you halfway down the page of 394? A period of 5 years following sentence was established as a reasonable, though not by any means inflexible, time limit. If execution was not carried within that time frame, there was a strong likelihood the court would regard the delay as amounting to inhuman treatment and commute the death sentence. And then what is perhaps helpful, because this comes from the Caribbean judges themselves, one from the Eastern Caribbean Court of Appeal and one from Trinidad, is at page 46, paragraph 46. And you look, the radical nature of the decision in Pratt, the suddenness with which it was sprung, the apparent stringency of the unpreparedness raised tremendous concern. The decision caused disruption in national and regional justice system. Its effect was that in one fell swoop, all persons on death row for longer than 5 years were automatically entitled to have and had their sentences commuted to life imprisonment. So that's how they interpret it, entitled to have and had. And over the page, one can see that they say that once everybody had settled down, they recognised that Pratt was rightly decided. So that's the Caribbean. So now that the initial dislocation is generally abated, it must be acknowledged that prior to Pratt, some states countenance an unacceptably lax approach to the processing of their criminal appeals. We respectfully endorse without reservation the proposition that the practice of keeping persons on death row for inordinate periods of time is unacceptable and infringes constitutional provisions that guarantee humane treatment. So two points. One, that it's the endorsement by the as it were, the local highest court, the CCJ, of the approach in Pratt. But two, the clear understanding that they become entitled after 5 years. So that would certainly refer to the 1993 batch. Against that background, at 1.3 of the speaking note, we make this point. The Court of Appeal held that there were two routes to the imposition of the term of imprisonment, that it was necessary to substitute for the death penalty. The first was by way of commutation pursuant to a judicial determination of a constitutional motion. My lords, that's in Pratt, volume 1, tab 42 at page 34A. Should I take the court to that? I mean, it says that we have to therefore determine the appropriate penalty. Yeah, and they do it in the exercise. It was a constitutional motion. It was in the exercise of their powers.
Yes, they suggest that instead of a whole swathe of constitutional motions, there be a remission by the President or whatever. Is that the point you're making?
Well, no, my lord, no. The first point we make is that the order they actually make is an order, and this is so. It's Pratt. Is it? Sorry, it's which volume is it? It's at page 2466. Yes, it's in volume 4, and it's page 2466 of the bundle. But I think it is important to distinguish the two phases. You have at page 2466 of the e-bundle, page 34, at A, the width of the language of this subsection enables the court to substitute for the sentence of death such order as it considers appropriate. The appropriate order in the present case is sentence of death of each should be commuted to life. So
that's on a constitutional motion. In that case, Jamaica, but the same applies in Trinidad.
My lord, yes. And so our first point is that's the only ratio, is that on a constitutional motion, which is, we submit, the appropriate and normal remedy, the court substitutes such sentence as it considers appropriate. In that case, life, but it could be less. And that is the court properly exercising a judicial function to provide the appropriate remedy and to fix the appropriate alternative term of imprisonment, which may be life, may be less. And we basically our submission is that is the primary and proper way to do it. Now then, obiter, we have from B onwards, their lordships are very conscious many other prisoners are awaiting the outcome of this appeal. In an attempt to assist the Jamaican authorities, who may be faced with a large number of appeals, their lordships wish to make some general observations. So what follows are general observations, and then they lay down the periods, and I won't go, but it's basically, they go through, if I can just give the suggestions, at E34F, capital appeals must be expedited and legal aid allocated to impediment at an early stage. The aim should be to hear a capital appeal within 12 months of conviction. The procedure contained in the governor's instructions should be reinstated, and then it must be made as soon as possible, as both the rules of the Judicial Committee and the governor's instructions require, in which case it should be possible to dispose of it within 6 months of the appeal hearing, or within further 6 months if those to be full. In this way, it should be possible to complete the entire domestic appeal process within approximately 2 years, and that includes the Privy Council, of course. Their lordships do not purport to set down any rigid timetable, but to indicate what appear to them to be realistic targets, which, if achieved, would entail very much shorter delay than has occurred in recent cases and could not be considered to involve inhuman or degrading punishment or other treatment. And then they go on to say 18 months for the conclusion of international appeals, which was still available in Trinidad. And then they come on at the end to give their helpful observation. These G35G, these considerations lead their lordships to the conclusion that in any case in which execution is to take place more than 5 years after sentence, there will be strong grounds for believing the delay is such as to constitute inhuman or degrading punishment or other treatment. If, therefore, rather than waiting for all those persons who have been in death row under sentence of death for 5 years or more to commence proceedings, the JPC, who in accordance with the guidance contained in this advice recommend commutations to life imprisonment, substantial justice will be achieved without provoking a flood of applications. Yes?
Yes.
Yes. The applicant, and then one sees the applicants.
Yeah, well, we don't need to look at that, do we?
No. Commuted to life imprisonment. But my lords, that's the genesis, as it were, of the two alternative routes. And the board has our submission that the proper appropriate route is the constitutional route. The other one may be, in some cases, an expedient. But can I just put it this way? Because we say consistently with the separation of powers principle, that is the proper route. If the president steps in first and commutes, let's say after 2 years, the prisoner may have no objection. We can't say it's without jurisdiction. But we do submit that that does not rule out resort to a constitutional motion to have it done properly.
Now, that's a departure, is it not, from your written case? Because I think your written case says it is without jurisdiction, that the Governor-General's or President's jurisdiction is confined to situations where there is a valid sentence, and you argued in the original case at some length that there isn't a valid sentence once the 5 years are passed. But you're not pursuing that now. No,
my lord. Can I put it this way? We say there isn't a valid sentence in force. That's it. And there are two remedies. One, a bad remedy, which is a stop.
It's an available remedy, but it's not the one.
Well, can I tell you why, my lord? And I hope your lordships would appreciate we've given very careful thought to why we've made this refinement, which is this. There might be a case where someone is commuted, let's say, to 10 years by the president. And he's got absolutely no complaint with that. And we've found a case where, this is a cabin boy case in the Victorian age, where the sentence was commuted to 6 months. So they're not going to complain about that. They're going to say it may be a stopgap measure, but that's okay. What we say is it can't exhaust your right to go to the court and say, I want a declaration that the death penalty imposed on me originally was unconstitutional, and I want a determination by the court. That's to say, even if there is a commutation, it doesn't rule out the right of the prisoner to say, I seek a declaration that the death penalty imposed on me was wrongly imposed, and I seek...
Gerald, it wasn't wrongly imposed, was it? That's
Sorry.
That's the trouble.
No, I'm so sorry. I'm so sorry. I seek a declaration that the death sentence had become ineffective, invalid.
I mean, the question which that raises, as I understand it,
yes.
which isn't an entirely new one,
No.
I think,
Yes.
is once there has been a presidential commutation,
Yes.
which I think you now accept he's got power to do.
Yes.
That, again, is different from what was previously being submitted, but there we are. Once there has been a presidential commutation, there is no longer a death sentence to be carried out.
Yes.
What then, the question becomes, is the source of the right to lodge a constitutional motion? Because, as I understand Pratt and Morgan, what the law establishes is that it's not the passing of the sentence that's unlawful, it's the carrying out of it when too long has passed.
Yes. But, my lord, what they'd be seeking, and it happened in Cord, for example, what they'd be seeking is a declaration that the death penalty after 5 years had become ineffective. Well, my lord, supposing they wanted to sue for damages, they could do that, and that happens in CPSAD. They would seek a declaration. Supposing that some of these people had been on death row for 10 years, they would seek a declaration that the death penalty had become ineffective, and that therefore they had been held on death row for 5 years in breach of their constitutional rights. And they would seek an appropriate remedy, and the appropriate remedy would be, 1, damages, and 2, an appropriate determination by a court, as in Pratt, where the court did the determination. And, my lord, that's our respectful submission, that the fact that there has been a mitigation of the death penalty by commutation does not mean that you have not suffered an injustice by being held on death row beyond 5 years, does not mean that you can't go to the court and seek a remedy for that injustice, which could include damages, but certainly could include, I wish to have a determination by the proper body, that's to say, a body that can determine the appropriate punishment. And that's where, in our respectful submission, the principle of the separation of powers comes in, that if a prisoner asserts his right and says, I want the alternative penalty to be determined by a court rather than by the executive, he is entitled to have that.
So the source of the court's power to substitute a sentence is what? Is the constitutional motion?
Yes, constitutional motion under
Is that submission made in substitution for or in addition to the submission which has been made hitherto, right up until yesterday, as far as I can see, that it's to be found in Section 70 of the Criminal Procedure Act?
No, my lord, it was both always. It was both always. I mean, my lord, yes, it's both always. And my lord, we've gone back to the speaking note before the Court of Appeal. The point about the alternative remedy has always been made. Indeed, we spend the whole of the last part of our case talking about the flexibility of constitutional remedy. And my learned friend knew it because he responded that it was not an unreasonable exercise of their discretion to send it back to the President rather than to the court. None of this takes anybody, with great respect, by surprise with in our submission. What we're saying is, if there is a proper route, which is the constitutional route, the President, by stepping in, or the national security measure minister, in fact, by stepping in, cannot exclude the right to go for a proper determination on a constitutional motion.
Well, if there are alternatives, as you now accept, then doesn't the constitutional motion, once the President or Governor-General has acted, have to be directed to whatever result arises from the President or the Governor-General's action? It may amount to the same thing in the end of the day, but can you go back to the original death penalty and say, forget about the President and Governor-General completely and anything they've done by way of commutation. We're not concerned with the reasonableness of that. You just look at it as a parallel, entirely independent procedure which goes over the same territory.
Yes, my lord, it would be a parallel and alternative procedure which you would only have recourse to if you were dissatisfied with the I mean, it's very much like
the alternative view might be that if they are both valid methods of dealing with the problem, once it's been dealt with by one method, then if you can really still pursue the other method, that method ought to be addressing the adequacy of the executive method.
Well, my lord, we respectfully submit no, because what we submit is the presidential commutation can only be, as it were, a stopgap measure, an expedient measure. It isn't a proper remedy for the fact that the death penalty had, after 5 years, become an ineffective sentence, an ineffective authority for detention, and had to be replaced. If the sentence had become ineffective and had to be replaced, on principle, the body that should replace that is a court.
I don't understand how you can have it both ways. In the jurisdiction of a court under Section 14 is to give redress for a contravention of the Constitution.
Yes. Yes.
And it can make such order as appropriate to give redress.
Yes.
Now, if it's going to make an order imposing a different sentence for the one which has been imposed by the President, then presumably that can only be on the footing that, that the order made by the President is a breach of the Constitution.
Well, I don't, my lord, I don't accept that. But in these cases, of course, we can satisfy that test because the order made by the President had to be set aside in any event.
Yes, but if a presidential order isn't in contravention of the Constitution, what jurisdiction does the court have to interfere with it?
Well, my lord,
under Section 14.
It's not interfering with it. It's a separate parallel right which has not been exercised.
You can't have two inconsistent orders simultaneously in force authorising the imprisonment of the same individual on different terms.
Well, my lord, the replacement or what the court would do is declare that the death penalty had become ineffective and impose the appropriate sentence in the exercise of its judicial discretion. And as a result of that, the presidential thing would, if necessary, it can be declared to be no longer in force, but it would fall away.
Well, hang on. What about the order, when the President commutes these sentences, it is Section 70, I think, requires, doesn't it, an order of the court.
Yes.
It does so in the...
Yes.
Wait a minute. It does so in the it does so first in the now atypical case where the pardon arrives while the court's still sitting, but also in exactly the same way when it comes long afterwards.
Yes.
Now, wait a minute.
Sorry.
Suppose that order has been made, as it has in these cases, by the Chief Justice. What happens to that, on your hypothesis?
Well, my lord, in these cases, it's very easy. It's been set aside.
Well, yes, but we're not so much concerned with these cases as with your normal case. Supposing that has happened and there haven't been the procedural difficulties that there have in these cases, what is the effect, if you are right, of a fresh and, as you would say, parallel constitutional motion on the order that will have been made under Section 70 of the Criminal Procedure Act?
That would be set aside.
How?
It would simply set aside as an unlawful, an ineffective order.
How?
Well, my lord, that's the whole point about Section 14. It gives a very wide and flexible remedy. And that's the point. I mean, listen, in Cord, that's what happened. The President had stepped in and given natural life. And the board still said, although he'd given an order for natural life, we're going to set aside that the board for natural life, the order made by the President for natural life, and we're going to have make an order that a new order in exercise of our wide powers of remedy, that the High Court should fix the appropriate term.
Can we look at that? Where is that?
Yeah,
What is the infringement of the Constitution that would lead to the result which you described in answer to my Lord Hughes? Are you saying that that Section 70 itself is unconstitutional? Are you saying it's unconstitutional to confirm a decision which, on the face of it, the Constitution assigns to the President? What is the breach of the Constitution which justifies the Section 14 motion?
My Lord, it's the parallel. Well, the breach of the Constitution was the holding of the person for more than 5 years on death row.
Yes, but once he's no longer under sentence of death, what is there?
Well, the court simply declares that the historical fact that he was held on death row beyond the 5 years was unconstitutional, and then says what is the appropriate remedy for us in exercise of Section 14 to give.
Well, I understand what you say the court should do. I'm trying to identify the breach of the Constitution which justifies inviting it to do anything.
Yes. Well,
What
my
is
Lord.
it?
Well, my Lord.
There's no longer a sentence of death.
Yes.
So what is the juridical basis for the application under Section 14?
The juridical basis is that there was a breach of the Constitution which has been imperfectly cured.
Imperfectly cured?
Yes, that's it.
So
That does depend upon addressing your complaint to the cure and saying it's imperfect, but you accept it's valid, it's with jurisdiction.
the imperfection, is that said to be a constitutional imperfection? Or
yes.
What is the constitutional imperfection?
The right to due process.
Right. Okay, but I mean, I think that I quite see that the audi alteram partem point here is a refinement the effect of which we've got to consider. But Lord Hughes's questions were put to you on the footing that that particular refinement didn't arise. So now...
Yes, no, well, even then, my Lord, even then our submission is that what has happened is that the President has done, as it were, the second best, removed it. It's within jurisdiction, but it's an imperfect cure for what happened.
So what you're saying is that it is a breach of due process for the President to impose a substitute term. Is that right?
Well, my Lord, what I'm saying is...
Well, no, breach of due process.
Yes, I do.
Assume you haven't got the problem of not being allowed to make representations, because we're looking to the future.
No, I appreciate it, yes.
Assume you haven't got that.
Yes.
You say it's breach of due process, and do I understand you correctly? The breach of due process is what you describe as the imperfect cure,
my Lord, yes.
Namely the presidential nomination
yes.
of a substitute sentence.
My Lord, yes.
And it's a breach of due process because?
Because it's the fixing of a term by the executive rather than the
separation of powers point.
Yes.
But the Constitution provides in terms for that very thing to happen.
Well, my Lord, it doesn't actually. What the Constitution provides for is... this situation obviously wasn't within the contemplation of the Constitution at the time. It provides for a classic exercise of mercy, which is the sentence which you had imposed on you was excessive, or as a matter of leniency, we're going to remit it. And that's the exercise, the classic exercise of mercy. Our submission, our respectful submission is this. That's not this case. What has happened here is that as a matter of law, the sentence of death has become ineffective. It has, as a matter of law, to be replaced by another sentence.
Yes, but I mean, you can't have it both ways. Either this is covered by the Constitution, or it's not. And as soon as you invoke the doctrine of the separation of powers, what you're really suggesting is that there isn't jurisdiction to do this. It's not covered by the Constitution. Isn't that the position? you're really saying that if it's a breach of the separation of powers, the President shouldn't be doing this in these circumstances, and therefore the constitutional power doesn't or can't extend to these circumstances.
My Lord,
you've already conceded that there is jurisdiction to do it.
Well, I think what I'm probably saying is there may be prisoners who don't want to complain about it, but as a matter of principle, it's wrong.
I can
Yeah.
see. Well,
I mean, well, my Lord,
The submission appears to be that the Constitution is in this respect unconstitutional.
well, my Lord, the Constitution
It infringes the separation of powers.
Well, can I just put it this way, my Lord? The Constitution doesn't tell the President in what circumstances it's appropriate for him to step in. And the classic case is, this is what Lord Bingham said in Ray's. Mercy, that the exercise of mercy is, this is the appropriate punishment, I'm going to give you less than the appropriate punishment. That's not this exercise.
But I mean, in that case, you should be submitting, the logic of your case is that you should be submitting that the President didn't have this power in the circumstances of this case, yet you appear to concede that he did.
Well, my Lord, I'm submitting that it's wrong in principle for that to be done by the...
We need to be a bit more precise, don't we, about what you mean by wrong in principle.
Well, it is a violation of the principle of the separation of powers.
I'm sorry, are you saying the President shouldn't do it?
He shouldn't do it.
Has no power to do it?
Well, my Lord, we're already in a...
That might come as some surprise to those who had the benefit of his orders.
In the delay cases.
Yes.
Well, my Lord, can I put it this way? If we look at...
Are you saying that he hasn't got the power to do what he did?
My Lord, I can't say he doesn't have the power. I'm saying that if a prisoner in any case, if a prisoner in any case says, I'm entitled to have it done in the proper way, that is to say, by a court, that he is entitled to assert that right, notwithstanding the fact that there has been an exercise of the prerogative of mercy.
You're using expressions like the proper way.
Yes.
He has the power, but he shouldn't do it. What norms are you appealing to?
Well, my Lord, look at a case like O'Reilly and Macman, where the court said that this is the appropriate way. From now on, you can't go by way of writ. You've got to go by way of public law. That was the court, and in this case it's the court constitutional, saying the appropriate remedy in cases like this is that the matter is brought by way of a constitutional motion. The constitutional motion results in the proper exercise of a judicial power, and as a result of that exercise of judicial power, an appropriate sentence is fixed. But the President exercising that power, we submit, is inappropriate. It may be you don't want to complain about it, but it's inappropriate.
I mean, correct me if I'm wrong, but my vague recollection is that O'Reilly and Macman was based on the concept of abusive process.
Yes.
It was an abusive process to pursue by ordinary actions.
Yes.
So that's a well-established common law legal principle.
Yes.
Being relied on.
Yes.
So what's the legal principle you're relying on?
Well, the legal principle is that the President, if the President chooses to do it, he cannot... Okay, it's this. The President, by his executive action in commuting, cannot rule out the right cannot oust the right of the prisoner to go to a court and to say to the court, declare the appropriate term. Because you have a right to have it set aside as the sentence set aside as unconstitutional. You have a right to have the term fixed.
So we're back at the alternative remedies point.
If
one remedy is excised, that doesn't include the other.
My Lord, can I try and do it the other way? Can I try, and I hope I'm not trying to dodge the questions put by my own lords, but I'm trying to take the situations, just take the situation of these appellants. Yes. Supposing they had no natural justice complaint, but the term that was fixed was, in their view, grossly disproportionate. Or they simply just hadn't had it, they weren't satisfied with the result. They would be entitled, in my respectful submission, to go to a court in the exercise of constitutional powers of relief and to say, I invite you to declare that the death penalty that was in place on December the 30th,
we understand.
December the 30th, 1993,
We understand your position.
was ineffective, that I am entitled to a judicial determination.
Yes.
What they would do, surely, would be not by way of constitutional motion at all. They would simply apply for judicial review of the manner in which an unquestionably existing constitutional power had been exercised.
Well, my lord, I submit that...
Say it was irrational or disproportionate.
But then that's at one remove, my lord. That's reviewing a power which is not the natural remedy and not the remedy they're entitled to. They are entitled...
Well, that's what we're...
Yes.
That's the whole point, Mr.
This is the whole point we're examining.
See, I'm trying to think what I say if I go along to the Constitutional Court on behalf of one of these chaps, and I get up and I say, step one, my original sentence of death, the carrying out of my original sentence of death had become unlawful, and they'll say, yes, of course, that's quite right. Now what?
Now I invite you...
Well, hang on. Then I say, we accept that the President could commute, as he has done,
Yes.
but we invite you to say that we have a constitutional complaint on the grounds that he ought not to have done.
No, we invite you to give the remedy for the wrong that was done us of being held beyond the time.
Yes.
We invite you to give the remedy for that, and the remedy is a judicial determination.
Yeah. Well, and the additional difficulty, which my Lord mentioned earlier, is that you've got another judgment standing from the Lord Chief Justice.
Well, that can be
Chief
said.
Justice.
Well,
anyway, you get
well,
that.
my Lord, with respect to the Attorney General, they can't have it both ways. On the one hand, they're saying the Chief Justice is exercising a purely ministerial rubber stamp thing, and on the other hand, it's suddenly become a judicial decision. I mean, either it is a real judicial decision, in which case he's got to exercise some discretion, or it's simply a rubber stamp.
Exactly.
Yes.
An order of the court is a rule of law.
It's an order.
Order of the court giving effect to a constitutional remedy, which you say is not the preferable one, and the problem is, I think we've probably gone over the sufficient.
All right. Well, my lords,
we ought to move on.
My lords, yes. Could I then, because I'll come back if I can come back to it, because at the very least, my lords, the Section 70 point is still pursued.
Yes.
As your lordships know.
So you say the Section 70 point actually is not, he's not a rubber stamp.
He's not a rubber stamp,
Chief Justice has power under the wording. Perhaps you ought to look at the wording.
Well, my Lord...
or is it under an interpretation of the wording to give it...
yes, it's under modification of the wording. Well, my Lords, can I just before we move on to the summary of our submissions, just indicate the nature because one of our arguments is this is the wrong remedy in this case, that the Court of Appeal had a choice of remedies and they gave the wrong one. And consistently with the separation of powers, they should have given the other one. Now, my Lords, we've set out the commutations in these cases, and your Lordships have at 1.6 our submissions on those. So the natural life was fixed at Roman 1. 5 years later, the 75 years was fixed, and then at Roman 3, page 6, now the procedural flaws the court has, that there was no notice, and the Court of Appeal accepted that. Moreover, there was clearly no individual consideration of the merits of the cases. And, my Lords, you have the attached analysis. Just to summarise the position, some of them, and this is at the top of page 8, were dealt with, for offences committed in the domestic context. That's Bim, Ram, Dishan Ram Fari, and then Fazal Amin Khan, where there was some evidence of diminished responsibility. And the offence of Norbert Williams was in circumstances of some considerable provocation, that he was commuted to natural life. And the point is, all of them indiscriminately, though some of them were of the greatest gravity, and though some of them were in situations of provocation or domestic killings with some evidence of diminished, all of them were given the same. So though the courts below did not find that there had been a failure to consider the individual circumstances, we say it's the inevitable, inexorable conclusion from the fact that those widely differing cases were all visited with the same penalty, that there was, in this case, a failure to consider the individual matters. Now, my lord, this may matter when it comes to the choice of remedy in this case, because the executive system has shown itself woefully inadequate, in our respectful submission, to deal with this. And indeed, the Court of Appeal at the end says this is going to mean a vast change to the way in which they conduct their business and an adaptation. We don't even know that the Constitution lays down that the board that advises the National Security Minister is composed of the Attorney General and the DPP, i.e. the people who are prosecuting them and seeking their execution, and then four other people nominated by the President whose identity actually is not known.
I'm a little surprised at the Court of Appeal. At the Court of Appeal being so surprised, I thought it had been established as long ago as Lewis in 2000 that there was a right to have some sort of individual consideration, make representations and all that. Is that not the case?
Yes, my lord. What the Court of Appeal had to wrestle with was the question of whether it was retrospective or not, and they found that it was. Yes, that was their ruling, that it was retrospective.
Yes. But I mean, were they suggesting that it had to be a radical change for the future? They weren't.
Yes, they were. Yes, they were.
Why would it have to be?
Because Neville Lewis simply hasn't been applied. My lord, they're saying this is going to require, I think it's paragraph 100 of their judgment, this is going to require a complete, paragraph.
Yes, Guerra is the other case, isn't it, which is also...
Yes, paragraph 99, page 782, we are not unmindful of respondents' concerns. Several individual assessments may now be expected with regards to the demands placed on the shoulders of the advisory committee, whose...
Could increase significantly.
Yes. New territory may have to be navigated by the advisory of the Minister of Now and the President, but all of them are an ineluctable consequence of the adherence. Well, they're not the ineluctable consequence. The ineluctable consequences is you give it to a court to do. And in this case, that was a perfectly open remedy to say, this has been done.
Yes, I mean, look, do they actually know whether the current procedure in Trinidad and Tobago is as inadequate as it was 20 years ago?
Yeah, well, my lord, they do. They are the Court of Appeal.
Yes.
They
do seem to put it in terms of may have and could increase.
My lord, the proof of the pudding is in the eating. We really do say, look what's happened in this case. It was simply a job lot, all 75.
This was before Neville Lewis. This was either 7 years before Neville Lewis in 2000 or 2 years.
Yes.
So one can understand the deficiencies then. Anyway, it may not matter for present purposes.
Well, my lord, we then have, if I can just take you through 1.9, the commutation, the judge's orders. We have the orders set out at 1.10, imprisoned for the rest of his natural life, and then the addition, that was Chief Justice Bernard at 1.10. They be kept in custody during the whole of the said term of his imprisonment. And then the second...
That's been dealt with by the Court of Appeal, Mr. Fitzgerald.
Yes, my lord, that's, yes. Well, my lord, at 1.13 we set out the Court of Appeal recognised the sentence to imprisonment for natural life could not be given literal effect, and that the words of the Chief Justice potentially set a tariff which is unlawful and potentially prejudices the appellant's right to review of their sentences. And then, obviously, they lead to far longer in actual custody than the usual periods. Now, my lords, the injustice that we complain of is we say at part 2 that the sentence of death had to be commuted. The only question then was the appropriate length for the term of imprisonment that should be imposed to reflect the gravity of the individual offences, any individual mitigating circumstances, and the respective magnitude of the breach of their constitutional rights.
Your primary case, can I just ask you to focus on Section 70, which you mentioned? Your primary case is that the Chief Justice or the Chief Justice should have done that at the stage when the matter was referred after the commutation by the President.
Yes.
How does that work under Section 70? Just looking at your original case, which sets out Section
yes.
70.
Yes. My Lord.
That only seems to deal with situations where the intention of mercy is signified by the President to the court during the criminal sessions at which such person was convicted.
Yes.
It does both, doesn't it?
Does that work?
Yeah, it does both. It says
it does both.
Section 70 it isn't divided into subparagraphs, but it could be. It deals first with the situation where intention of mercy is signified by the President during the criminal session.
You haven't set out the whole of it, then?
No, exactly.
You haven't.
You've left out,
well, my Lord,
you've left out the bit that you actually need.
Well, my Lord, can I take you to a volume? Well, my Lord, we've said it out. But can I just, can I take you to the actual text, which is volume 1, tab 2, and 70. When any person is convicted of any crime punishable by death, if the President, in the name and on behalf of the State, intends to extend mercy to any such person upon condition of imprisonment, and such intention of...
We need to read the next bit, and where such intention of mercy is so signified at any time when the court is not in session. That's the critical bit. Yeah.
Yes. Yeah. The Chief Justice shall allow to such and make an order. Now, what we say is for an appropriate, the order must be for an appropriate term of imprisonment.
No, that's not what it says.
No, I know, my Lord, but that's the whole point about constitutional modification.
Okay, right.
You could read it.
Yes,
listen, sorry, I'm sorry.
So do you therefore say that the same would apply in the event that the pardon arrived before while the court was still in session? In other words, do you say the same principle applies to each half of Section 70?
That he shouldn't...
That the court... if the pardon arrives with a sentence, a nominated commutation,
yes.
If it arrives the day after the sentence has been passed, and so it's in the first, the court is still in session, does the same apply, that the court then says, well, never mind what the President says, we'll start again?
My Lord, this is where we have sort of slightly refined the point. What I do, no, well, my Lord, I hope.
Yes, okay.
I hope that it's not a crime for
let's
counsel,
get it right.
in the light of submissions of the other side, to reconsider and refine.
Right.
What we respectfully submit is that what the Chief Justice cannot do is to give effect to a term of punishment which is so inappropriate as to be cruel and unusual punishment, and that can be read in by the power of modification, because he'd be giving effect.
Yes.
And, my Lord, the authority for the extensive power of modification is the series of cases on detention during the Governor-General's pleasure, where the court, in the exercise of the power of modification, substituted for detention during the Governor-General's pleasure, or the State's pleasure in some cases, detention during the court's pleasure. In other words, it is an established power of modification to simply substitute the judiciary for the executive, completely.
Right. So the answer to my question is it that would apply whenever the pardon with its commutation arrives, whether it's immediately, Part 1 of Section 70, or after a 5-year delay, or indeed after some lesser delay, Part 2?
Yes.
Yes?
Yeah, my Lord, the Chief Justice, in our submission, yes, my Lord, he can never give effect to something which constitutes cruel and unusual punishment.
But that's not the question. The question is to what extent can he depart from the term, the substitute term, which the President nominates as part of the pardon. Leave out, you've got a second point, if the substituted sentence is itself cruel and unusual punishment. Let's get to that later. For the moment, supposing it isn't,
Yes.
can the court depart from it?
Well, my lord, that's our first submission.
And can it go either up or down?
No, well, my lord, that's our first proposition, my lord, is that the. Sorry, my lord. Can I try and put it this way? We say that what he substitutes is I mean, we have set it out. Can I just show you, Your Lordship, in where we've set it out? If Your Lordship looks at our summary of our submissions, we say at page 22 at Roman 1, the selection of the
Your submissions, the case.
in the speaking note, my lord, at page 22, the selection of the substitute penalty, where the death penalty cannot stand, is a matter for the judiciary, not the executive. Then we say, secondly, the proper remedy is that the court, on a constitutional motion, decides it. And then our third submission is that the Court of Appeal selected the wrong remedy, and that's dealt with at part 6 of the submissions. And then our fourth point, at 3.5, is that the Chief Justice has a duty to review the sentence.
Yeah, but I'm sorry, I understand all of that, but I want to see where it goes.
Yes.
Supposing that the sentence of death is passed on the 1st of March, and a week later the commutation arrives and the President commutes the sentence to 5 years.
Yes.
What is the Chief Justice's power?
My lord, my submission is the power of the Chief Justice is to disallow a penalty which is a cruel and unusual punishment.
Well, that may, all right, that's
Presumably the President couldn't exercise his power under the Constitution so as to substitute a cruel and unusual punishment either.
No, my lord, but the point is, we don't want to wait. I mean, the real problem is this. At the moment, the envisaged remedy that my learned friend in the Court of Appeal leave one with is, the President is the initial and primary decision maker.
Yes.
If they get it wrong, you go for judicial review. But that leaves, well, my lord, that is...
On the length of the sentence?
Yes, judicial review, yes.
Really?
Yes. Well, that's what the court says. That's what my learned friend says.
If the President exercised his undoubted constitutional power, let's assume it was undoubted, in a manner that was irrational,
Yes.
which would no doubt include a case where it involved substituting a cruel and unusual punishment, then you would judicially review the way in which that power had been exercised by the President, wouldn't you?
Well, my lord, you could, but what we're saying is that those prisoners who don't have the resource, this is a very real, they don't have the resources to mount a judicial review, or the knowledge, or the inclination, or the awareness to, should not be bereft of a remedy. The Chief Justice should not enter into the record a sentence which may well be, and can I just try and indicate, or is, cruel and unusual. In a case like this, can I try to come down to the practicality before the legality? I'm sorry, but my lord, can I put it this way? In a case like this, he gets 47 cases where they've all got life, and if some of them he'll know because of the case. If it's self-evident that what has been done is that a wholesale commutation to one unindifferentiated term has been imposed, he could simply say, I'm not prepared to record these until I'm satisfied that you have exercised individual consideration. But we do submit that the Chief Justice cannot be required under the Constitution to record a sentence which is cruel and unusual.
Yeah. So, I mean, the logic of this part of the case...
He's a second guesser.
Well, he's a second guesser.
Well, we would say he's obliged, and all you have to do is write in the word appropriate.
Yes.
Before
The truth is, he's not a second guesser. He ought to be a decision maker himself.
Yes.
He's,
Yes.
on your case, and if he is a decision maker, I mean, if we hold that in this situation,
Yes.
Section 70 makes him a decision maker, then actually, doesn't it follow that any question of a separate constitutional motion
Would not arise.
Doesn't arise?
Yes, no, I accept that, my Lord. I accept
It would also follow, wouldn't it, that it wouldn't matter whether there was something wrong with the way that the President had exercised his constitutional power. The Chief Justice would simply have a parallel power which would overtake the exercise of the President's power. He might simply say, well, the President was perfectly within his rights to substitute a sentence of 50 years, but I think that the right amount would have been 35.
Yes.
But I mean, so it does seem to me that you are maybe confusing the issue by eliding the question whether the President's sentence was cruel and unusual or attackable in some other ground, and the question whether he had such a power at all. Because leaving aside for a moment the question of a defect in the way the President exercises his power, the submissions that you have made all require you to say that the words substitute a less severe form of punishment for that imposed do not extend to the President saying you will instead serve X years or life.
Yes.
If you don't say that, then it seems to me that the position is that the President has a power which determines the sentence as a matter of the Constitution of Trinidad, and that the only way of attacking that is to say that he exercised that power in the wrong way, which is a matter for judicial review. However you deal with it procedurally, that's the test.
Or constitutional motion, my Lord, it would be.
Well, if it's a constitutional motion, you have to show that there's been a breach of the Constitution. If he had a power to do it, but simply exercised that power in a manner which is contrary to the ordinary principles of public law, that's not a matter for the Constitution, is it? It's a matter for judicial review.
Well, my Lord, in these cases, the remedy for the breach of the rules of natural justice was given in a constitutional motion, and it was given by way of constitutional relief, because there is, in Trinidad, a well-established principle that a breach of due process.
That's because the particular concern here was, as you say, a want of due process by failing to receive representations. But if that, I mean, again, there are various ways in which you can attack a decision. If the only basis on which it's sought to be attacked is that the sentence, although within the powers correctly exercised of the President, differed from that which the Chief Justice would have awarded on a Section 70 application, then there's no basis for a constitutional motion, is there?
No basis, no, my Lord, no.
But that's what you're submitting, really. You're submitting that the Chief Justice has a completely independent parallel power, which upon its exercise supersedes whatever power may already have been exercised by the President, however lawful its exercise.
That, my Lord, that is our first submission. I accept that.
And can we test it, Mr. Fitzgerald? I'm sorry to sound like
No,
a scratchy record, but supposing the pardon arrives with a commuted term of 5 years, which the Chief Justice regards as absurdly short, supposing some mistake's been made, it's a very serious multiple killing or whatever, has he or has he not got the power to say nonsense?
Well,
20.
my Lord, on our first submission, the answer is yes. That's to say the submission in the case.
On the basis that he is the primary decision maker.
Yeah, he is the primary decision maker, and it's just the price to be paid for having a judicial determination. Proper, I mean, in other words, proper respect for separation of powers may in some cases lead to an increase made.
If that's right, and let's just test it out, what has the President done? Because don't forget, what he has done is to issue a pardon conditional.
Yes, I accept.
Now, your theory is it that what the President has done is to effectively set aside the death sentence without putting anything in its place?
Well, he's put something in the place which the Chief Justice then...
No, he hasn't. Not on your submission. On your submission, he's set aside the death sentence and left the Chief Justice the substitute sentence.
Yes.
So it isn't a conditional pardon under Section 87.3 at all, is it?
Well, because the Chief Justice on the section is giving effect to the conditional pardon.
No, he's not. That's the point.
Well, sorry, my Lord.
Forgive me.
As a matter of literal construction of the section,
Yeah.
what the Chief Justice is doing is giving effect to the conditional pardon. As your Lordship observes, that means if he says, I'm commuting this on condition you served 99 years, you give effect to that because it's, as it were, the two cohere together.
Yeah.
I'm setting aside your death penalty on condition. Yeah. Now, my Lord, our first submission in the case was, and remains, that the Chief Justice should, in order to give effect to the principle of separation of powers, determine himself what the appropriate term is. Our second submission, and this is set out in speaking at the alternative submission, is that at least the Chief Justice should not give effect to a period of imprisonment that is, in his view, cruel and unusual.
Well, that's...
And my Lord, we say, if one asks the question, well, how would he know? He would know very well in these cases. I mean, he may not in every case, but if he does know, because he would see these cases, some of which had come before him, varying from a domestic killing or a killing under considerable provocation or a case of borderline diminished to killing in the course of robbery with a shotgun, have all been given the same term.
Oh, so it's your proposition that the absence of individual consideration makes the sentence not only, makes the sentence cruel and unusual punishment.
Again, my Lord, for the authority for that is Ray's, which says, Ray's paragraph 44 says that what was cruel and unusual about the mandatory death penalty was the failure to have regard to individual. Can I just show?
Well, I remember that.
Well,
that's a death penalty.
My Lord.
Mandatory character of the death penalty.
Yes, but if one asks oneself what was the fault that was identified as making it cruel and unusual, it was that there was no differentiation between widely differing areas of culpability. Moreover, Lord Bingham recognised that the same principle had been applied by the Canadian Supreme Court to sentences, and that if you had a mandatory minimum sentence, it could work the same in justice. And that's in the case of Smith, because it might impose the same undifferentiated penalty on widely differing cases. And moreover, he recognised the same would apply to a sentence of life imprisonment in the case of Lichniak, at paragraph 8, where he says, if I had thought that the mandatory sentence of life imprisonment condemned each of them to lifelong custody without any differentiation, I would regard that as Article 3. So it is a principle, a well-established principle in the Canadian Supreme Court, in our Privy Council, in the House of Lords and now the Supreme Court, that the very fact that you impose a massive term of imprisonment, a lifelong term of imprisonment, or the death penalty, without any consideration of the individual circumstances, is of itself a cruel and unusual punishment.
Well, that answers that question. Now, can I go back, please, to your first and principal submission, which is that the Chief Justice is the primary decision maker when the conditional pardon arrives. Now, I'm sorry, I'm lagging behind, Mr. Fitzgerald.
No,
If the Chief Justice is the primary decision maker and the conditional pardon arrives from the President saying, I commute the death sentence on condition that the substitute sentence is, shall we say, 25 years, if the Chief Justice is free to ignore the second half of that, has the President commuted the death sentence or hasn't he?
Yes, he has, my Lord.
How?
Because he has said this isn't, well, in the case like this, he said it's inappropriate for the death penalty should not be imposed.
But he has only done it on condition.
Yes, my Lord. And we say that the condition can then be modified by the Chief Justice.
All right. Thank you.
In other words...
Chief Justice is not exercising an independent sentencing power, but a power of modification of the President's decision under 87(2)(c. Is that right? The Chief Justice is not, on this submission, exercising an independent sentencing power, but what he is doing is modifying a decision of the President under Section 87(2)(c) of the Constitution.
Yes, I'd accept that he's giving a judicial component to that. He is, I mean, my Lord, in these cases, of course, the analysis which we urge on your Lordships is that the death penalty had become ineffective, some penalty had to be imposed, and therefore...
You do have to accommodate that submission, don't you, within the language of the Constitution?
Yes, I accept that.
I mean, there's no difficulty, Mr. Fitzgerald, in understanding that the common lawyer's instinctive feeling is that sentencing ought to be for judges rather than for the President. Your problem is that in this instance, the Constitution appears to make it for the President.
Well, my Lord, no. Well, my Lord, we say this is a special case. For example, where the penalty is invalid ab initio, it's been accepted that the proper thing is for the court to set aside if it's a mandatory when
that's because there's never been in effect a lawful sentence of death.
Yes. Well, my Lord, we seek to extend that principle and to say where the death penalty has become ineffective,
it's the same.
Of delay, it's the same.
Yes, but it is.
And then, my Lord, we say that the principle of the separation of powers operates and applies.
Yep, understand.
That there is a selection of penalty to take place.
So in the ordinary case, if Section 70 were being applied because the President felt like being generous to someone who he thought had done other good things for the state, and perhaps might be let off the full severity, in that situation, there wouldn't be any question of the original sentence being not executable or anything, and then the Chief Justice would just be a rubber stamp, would he?
Well, my Lord,
he could.
He probably would.
Exercised on political grounds. Was the President's.
Yes. No, he wouldn't interfere. Well, we're not envisaging. We're envisaging that in a situation where the death penalty has been set aside because it has become ineffective and no longer a lawful authority for detention, the position then is that a sentence of imprisonment that is lawful has to be substituted in order to authorise detention. Well, and then as a matter of principle, we say, who should do that? The answer in our respectful submission is resoundingly the judiciary. Now then,
how do you accommodate that within 87(2)(c)? I mean, I can see that if you were writing the Constitution, that might be a good answer.
Well,
but if you're construing an existing one...
Well, the 87(2)(c) was not devised to deal with this position because the position simply hadn't arisen. So one then has to say, well, now that this situation has arisen, what is the appropriate remedy? And, my Lords, we can't say that the President can't do it. We can say that if he does it, the Chief Justice is entitled to say, is this the appropriate term that has been substituted? And two, we're saying respectfully that the proper remedy is by way of constitutional motion, and that if a prisoner invokes his right to seek a constitutional remedy, he's entitled to that constitutional remedy. I mean, my Lord, that's the way we put it.
I mean, the problem is you're appealing to an idea of a principle of the separation of powers as a constitutional principle in the face of a provision of the Constitution which expressly allows the President to substitute a punishment for the sentence imposed by a court.
Yes, my Lord, it does, and I accept that there is the dilemma of how you declare that to be unconstitutional, which is within the Constitution, and that, my Lord, the only way that we submit that, first of all, one actually has to say, what are we dealing with? We're dealing with rights. What is the right of someone who has served more than 5 years in custody? Their right is that the sentence cannot be carried out, therefore the sentence has become ineffective. What is the further right? Their right is to have a term of imprisonment imposed in substitute, otherwise there's no lawful authority for their detention at all. And then the question, once there is a choice, should it be 99 years or should it be 10 years, we say as a matter of principle, that should be exercised by the judiciary. Now,
the difficulty about this is that the logic of your argument is actually ultimately that we should be construing Section 87 as not applying to this situation. We should be going back to your original written... That's the logic.
I accept that, my lord. And
I
apologise if I haven't assisted the board by abandoning that position. I apologise to my learned friend, Mr. Delzin, who took that more radical and thing below. My lord, it stands if the board.
I think we.
But my lord, my lord.
In every way, Mr.
No, my lord. But the reason for the abandonment was precisely the position of the person who has had it commuted to 6 months, let's say, right. Where he simply doesn't want to interfere with it.
But if you're right, the Chief Justice ought, in a situation like that, if it's much too short, to be saying, well, never mind 6 months, the right sentence here is
my lord, that's our
years.
first argument, but our second refined argument, if I can call it 3A and 3B, is no, the Chief Justice at least has the power, in fact the duty under the Constitution, not to endorse a sentence which is a cruel and unusual punishment. And my lord, that's an entirely reasonable thing. If in the exercise of constitutional modification of a statutory power, you can substitute the word court for the word executive, which is the most radical thing you could possibly do, you must be able to read in the word appropriate or not cruel and unusual.
The thing about this is that though it does turn the Criminal Procedure Act section 70, yes, into a full-scale trial procedure. It's not good enough to say that the Chief Justice should not act in the face of a cruel and unusual punishment. He's got to have submissions on it. He's got to have evidence about the position.
Yes.
How does he know whether a punishment is without individualised consideration? And so, in truth, we would be, I mean, maybe we should, but we would be making this into a separate provision for a constitutional motion.
Yes, but in these delay cases, it would be perfectly possible to say where the case is a delay case, because it's a special category, he should exercise that.
Yes, but if the principle is that the Chief Justice must not endorse a sentence which is cruel and unusual, does it not follow as a matter of principle that he must examine every case that comes before him in order to determine whether it's cruel and unusual punishment?
Well, if there is anything to indicate it might be, yes.
Well, why confine it to that category of case?
He would be failing in his duty not to call for submissions and to investigate.
Well, my lord, in that case, so be it. I mean, but I do say that it's perfectly possible for the court to say, in a case where the commutation has been by delay, the Chief Justice should.
Of course, it's easy in that case because the answer is clear, but we've got to fasten upon your principle, and your principle seems to be that he must not endorse a punishment which is cruel and unusual.
Not where the punishment has been imposed as a substitute for an ineffective penalty. That's the principle. I mean, I know.
Fair enough. But that means, surely, that every case that comes before him, he's got to look at it and ask himself the question, do I have enough information to allow me to make a judgment as to whether or not this is cruel and unusual?
Well, my lord, in every case where it's a commutation by reason of delay, we do submit that he should, yes. And I mean, he knows because in this case, I mean, this isn't sort of, as it were, a Delphic procedure where you just get 75 years commutation. You get a memorandum the Chief Justice does explaining why they're doing it, which makes it quite clear to him this has been done on grounds of delay. And then we submit that once he gets that, I mean, he got a memorandum making it quite clear to him what had happened in this case and why he was being asked to endorse it. Indeed, that's why he wrote in, we presume why Chief Justice Bernard, the first of the Chief Justices, wrote in and shall be detained for the rest of their natural lives. So they were aware of those matters. So we do say, yes, in a case where the sentence is ineffective, where there had to be a substitute penalty, and where that substitute penalty was imposed by the President, and given the circumstances in which it was imposed were self-evidently arbitrary and disproportionate, the Chief Justice should have declined to give effect to it. My Lord, that is our submission. But to do otherwise would be to require the Chief Justice to give effect to a sentence which we say was, I mean, it carried on its face all the indicia.
Yes. No, we've got that point, and
I'm sorry.
Probably we've covered Section 70.
Yes. All right. Well, my Lord, you have our summary of our submissions at page 22. So we say selection of the substitute penalty is a matter for the judiciary, not the executive, and the proper remedy is by constitutional relief. Thirdly, we submit that the appellants in this case, this is at page 23, were entitled to a remedy that ensured they too had a judicial determination of the appropriate term of imprisonment. Once the Court of Appeal had found the exercise of fixing the appropriate substitute penalty had been unfairly conducted in the appellant's cases, it could and should have ordered the High Court itself to determine the appropriate term and declared the death penalties unconstitutional. My Lord, that's our submission. And, my Lord, we've given you a number of examples where the death penalty has been set aside. Courts in Belize and indeed in Trinidad have accepted that they have a power to give less than life imprisonment. Indeed, that's accepted by the Court of Appeal in this case, because they upheld 75 on the basis it was less than life. And then, therefore, we submit the Court of Appeal acted unreasonably and unlawfully in remitting the matter back to the President, effectively the Minister of National Security, who is part of the executive, to determine the quantum of punishment. So we say the objection to the Court of Appeal's limited remedy is based both on constitutional principle and on the unreasonableness and unfairness of their choice of remedy in all the circumstances. Well, that's the submission that we make in relation to that. Now, your Lordships have our submission about the duty to review the sentence, and finally, the sentences are unconstitutional by reason of the absence of a review mechanism is at 3.6. Can I just take your Lordships then briefly through those points as we've summarised them? Our first proposition in the case, and our first proposition set out at Part 4, is that the terms fixed by the President and recorded by the judge were effectively substitute sentences in circumstances where the sentence of death had become unlawful or at least no longer had legal effect. And, my Lords, we set that out in the case at paragraphs 8 to 19, and that is our proposition. That, in effect, the sentence had become unlawful, it had ceased to have legal effect, and it had to be replaced. Now, the Court of Appeal, and we've set out this at 4.2, we say we're wrong to hold that the right to be resentenced by a court only arises where the original sentence was void ab initio, and to hold further that the appellants were not entitled to the commutation of their sentences on grounds of delay. Because they say they weren't entitled, but I hope I've shown your Lordships through, by reference to Pratt, Henfield, Guerra, and indeed the Caribbean Court of Justice, that they were entitled to have their death sentences set aside. At 4.3, we submit that once a sentence ceases to have legal effect, there is need to replace it with a lawful sentence that does have legal effect. And where there has been a prohibited period of delay, the death penalty can no longer be lawfully carried out. My Lords, we've put in the extra bundles that this series of immigration cases where it's established that you can't detain someone for deportation once it's no longer possible to deport them. And we would say you can't detain someone on death row once it's no longer legally possible to execute them. So that these people are actually on death row, some of them, and 2 of them for 10 years. Their detention awaiting execution was unlawful because they could no longer...
Just take out the emotive expression death row. Do you mean that it was unlawful for them to be in prison at all?
It was, yes, there was no, yes, because, yes, my lord,
they're entitled to walk out, and anybody who stopped them would be assaulting them.
That's, well, my lord, can I put it this way? The point at which it becomes unlawful, and this is what the immigration cases help, is that there are some, as it were...
Yes, but forgive me, lumber, which is the kind of case you're talking about, is a case on the statutory provision in the Immigration Act which gives a power of detention ancillary to deportation. There's no analogy.
Well, my lord, can I just put this?
Or is it yours?
Well, there is an analogy,
right.
actually. What the judge does is say, I sentence you to death.
Yep.
That must carry with it, by necessary implication, the power to detain until you are executed.
Part of the sentence.
What? Yes, that's part of the sentence, yes. And you will be detained until. And therefore, that's authority for you to be detained until you are executed.
Yeah.
If there comes a point where everybody agrees you cannot lawfully be executed, you cannot be detained because you're being detained pending execution.
Right.
Now, my lord...
Well, that assumes that there is a gap which can't be filled.
Well, my lord...
Anyone surely would say that if the law is that after a certain time the execution of a death sentence is no longer permissible, then it doesn't necessarily follow that you are entitled to release. The implication may be that you're detained pending resentencing.
Well, my lord, there's nothing...
But why isn't that the natural implication?
My lord, can I try and answer that in two phases? In some jurisdictions, such as Belize, it's set out that the alternative for the death penalty is life imprisonment.
Yes.
It's set out in the statute.
Yes.
And then you can say, well, don't be so silly. If you're, the statute itself recognises that if you're not sentenced to death, there's authority to give life imprisonment as the alternative. So it's one or the other. But here, Trinidad, and this is the vice of the mandatory death penalty, there's no or such alternative term of imprisonment as a court determines, because it's not there.
No, but you have to adjust the original sentence, don't you? You accept under a constitutional motion. Why shouldn't the adjustment include the implication I suggested, namely that
until your period.
You're no longer detained pending execution because the execution is impermissible, but you are at that stage detained pending either commutation or resentencing on a constitutional motion.
Well, my lord, I would say you could be detained pending resentencing, but not pending.
Yes, yeah. But what we're, I think, testing you about is whether you're saying that you can walk out of the prison.
No, what I'm saying is that you could, that because there would otherwise be an unlawful detention at some point, there has to be a substitute sentence, and therefore the fact that there has to be, in a typical commutation case, there doesn't have to be a substitute. It's just a matter of grace or mercy. You had 40 years. We're going to give you 20 years because you've been well-behaved in prison. That's the typical, the deserved penalty has got, here the deserved penalty cannot be given effect. Therefore, there has to be a substitute penalty. And we do respectfully submit that changes the whole legal landscape. Therefore, the exercise then is the determination of what is the appropriate term, and that's the well, my lord, I don't think I need to persuade the board that that's a quintessentially judicial function. But if I do, we've set out all the cases. It's Anderson, it's all the cases on detention during the Governor-General's pleasure, that the determination of the period that is merited as punishment is a matter for the judiciary. And we've set them out in the speaking note from 2.8 onwards at page 18. And we've set out at 2.9 the underlying principle is it's not the case that every convicted murderer deserves either the death penalty or in the alternative lifelong punitive custody. And we've cited Lord Bingham in Lichniac. Therefore, a fair system has to be devised for the selection of the actual penalty. This is at Roman 2 on page 20. And in the case of life sentence prisoners, the actual length of custody to be served as punishment for the individual offences. Once we say that necessity is recognised, the selection of the appropriate punishment for the individual offence must be a judicial decision, and Lord Steyn so held in Anderson. The selection of the appropriate punishment for a convicted murderer, once there is a choice, must be done by the judiciary.
Regardless of Section 87 of the Constitution?
Yes, because that wasn't fitted for, that wasn't, I mean, that's not the mechanism, that was to cover everything under the sun. But Section 87 wasn't devised to deal with this situation at all.
No, but the reason I'm putting it to you is because its existence as part of a constitution, we've been over this already.
No, I understand, my lord.
It's difficult to reconcile at first sight with an absolute rule that sentencing must be done by judges.
Well, my lord, we say and my lord, that's why in trying to unravel that apparent conflict and not say the Constitution is itself unconstitutional, but to be true to that principle, what we say is that if a person, I know I'm repeating about it, but that's why it is really important. We say if a person says there is a principle that I'm entitled to invoke, that the period of detention I as a convicted murderer should suffer, the term of that should be determined by the judiciary. Yep. If he invokes that right, and that's why some people may not invoke that right. They may say, I'm content with what the president has done. I'm not going to quarrel about it. But if you invoke that right, and that's why it's only a person aggrieved who has the right under Section 14. He's aggrieved by the violation of his rights, and therefore he seeks the enforcement of those rights. He's entitled to say, I want the courts to give effect to that right. And the fact that others may say, well, I'm content to live with the second best, cannot prejudice the person's right to say, that is the remedy that I seek. And so we say that you are entitled to go to the court, notwithstanding the setting aside of the death penalty and substitution of another penalty by the president, to give effect to the right to have the period of detention determined by a court rather than the executive. My Lord, that's why, in fact, we say that you never lose that right. You may not choose to exercise it, but you never lose it.
So effectively, you can acquiesce in an unconstitutional decision, but if you're not prepared to acquiesce in it, then you can challenge it under Section 14.
Well, you can, yes, my lord. That's really it. I mean, you could acquiesce you could acquiesce in a situation where your rights have, as a matter of expediency, or your term as a matter of expediency, been determined by the president. I mean, given, sorry. Well, I'm not sure that's right.
We should probably move on. I think we've got that.
My lord. So that's the appropriate. That's why at Part 5 is the appropriate remedy is by way of constitutional motion, and the second point is the appropriate remedy in these particular cases. And my lord, our submission is that the appropriate remedy in these particular cases, where there has been, and we deal with that, if I can, yes, 5.1, but if we go to look at that at Part 6, at page 30, in any event, in these particular cases we submit, the presidential commutation exercise was conducted unlawfully.
So we moved, this is a separate point, is that we're examining,
Yes. What should be done in these cases? We say they certainly have invoked constitutional protection, and this has resulted in the breach of the appellant's constitutional rights. The Court of Appeal has made a finding that there's been a breach of the appellant's constitutional rights by the manner in which the President, acting on the advice of the Minister, determined the appropriate periods of imprisonment to be served in lieu of the death penalty. The question then is what the appropriate remedy is. The Court of Appeal held that the appropriate remedy was no more than to remit the matter to the advisory committee and the President for them to determine the appropriate commutation periods anew in the light of any representations made by the appellants after disclosure of the materials before the advisory committee. Now, we submit that this is an inadequate and unjust remedy that denies the appellants due process and the protection of law and their basic entitlement to a judicial determination of their tariff periods. That's because their tariffs will almost certainly not be determined at an oral hearing. They will not necessarily be entitled to a reasoned decision. The decision in Neville Lewis, which the Court of Appeal relied on, does not require the decision maker in the mercy process accords an oral hearing. Indeed, it's difficult to see how the committee, which has a policy of not disclosing its membership in case of possible reprisals against the extra 4 members, could accord an oral hearing, because then they'd all be known. Now, if you've got that alternative, you won't go before the advisory committee, you won't have an oral hearing, and the decision will be made by a politician. There is no duty to give reasons, although Neville Lewis leaves it open. And the level of scrutiny, my lords have been operating on the assumption that the level of judicial review will be an exacting level of judicial review. That's in the Neville Lewis case, they did say if it was unreasonable there would be a review, but they gave the example of the red-haired person, and they didn't suggest that the substantive review would be an exacting one. And the ultimate decision makers will not be the judges, but the Minister of National Security. The National Security Minister gives advice, and that advice, my learned friend and I agreed, under 87, is the President has to act in accordance with that advice. So effectively, that minister is the decision maker. I can give you the references for that. It's the Trinidad States argument in Guerra, Volume 2, Tab 19, page 402G. It was argued and not rejected that it was the National Security Minister whose views had to be followed by the President, and Lord Bingham in Matthew, although it was in dissent, it was on a different, there was no questioning of his decision on this. Volume 3, Tab 35, at page 2206, paragraph 62, he was saying, effectively, the decision maker is the national security measure. So who is advising? The DPP, who has been seeking conviction and the death penalty, the Attorney General, who is the respondent, again, to these cases, or and then 4 unnamed people. We say that for the Court of Appeal faced with a choice, and my learned friend Mr. Delson certainly did argue that the appropriate remedy in these cases would be by way of redetermination by the High Court. It's objectionable for the reasons of principle founded on the separation of powers that were set out by Lord Bingham in Reyes and Bow, which we've cited. And my lords, we've given you the citations, but perhaps I could just, we set them out in the case too. But Lord Bingham in Reyes states clearly that the determination of the appropriate punishment for a convicted murderer should be by the judiciary, and that the Mercy Committee is an inappropriate remedy because what the exercise they're conducting is of giving something less than the penalty that was deserved. And we know that the penalty in this case no longer was the death penalty was deserved. Moreover...
But Reyes is dealing with the original sentencing, isn't it?
Yes, it is, my lord. Yes, but he's saying as a matter of principle that to determine... But Anderson is, of course, you've been convicted of murder, you've been sentenced to mandatory life. The question of who should determine the punitive period.
Well, yes, but the difference, which is going to cause the trouble for us, is that in this country there is no entrenched constitutional provision for the President to do the job. Hence there was scope for the decision in Anderson.
Yes, well...
As I say, there isn't a problem in convincing most common lawyers that instinctively, on the face of it, sentencing is a matter for the courts.
But my lord, when you've got two choices, which the Court of Appeal have...
Question of whether you have.
Well, my lord, there's no doubt that they could have referred it back to the High Court for determination.
Really?
Yeah, no doubt. The court, supposing that the wrong term had been fixed, the court has the widest powers. That's what we've set out in the case.
Sorry, what do you mean the wrong term?
Well, my lord, the term had been fixed without a hearing, and had been fixed in a therefore, the process that had been engaged in had to be set aside. So you then get to a situation where you've quashed the commutation. Now, you can refer it back to a court to determine the appropriate term.
And the power to do that is?
Under Section 14 of the Constitution.
Oh, I see.
The widest possible... Well, my lord, perhaps we could look...
No, we've been there. Well, it's the same point that you've made before. Yes, go on.
Well, my lord, the one thing we did set out in great detail in the case, whatever criticisms if I can just take your lordships to it, is that the power of remedy and
is very wide.
Is very wide,
yeah.
And indeed that's the whole point about Part 4 of our
which are you referring to?
1047 in the case.
Sorry, what paragraph?
Paragraph 52, page 1047.
Yes, I don't think we were criticising your original case. So, yeah.
On the
Yes, I'm sorry. You have to let me have one jab back after taking being a punch bag all morning. I'd also, but 1047, Section 14 provides, as relevant, the High Court may make such orders, issue such writs, and give such directions as it may consider appropriate for the purpose of enforcing or securing the enforcement of the provisions of the fundamental rights to the protection of which the person concerned is entitled. This provision confers the widest possible jurisdiction to fashion remedies to secure the enforcement of fundamental rights. This includes the power of the court to determine the appropriate term of imprisonment, see Pratt. So the court, we say, should have declared that they actually said that the sentences weren't viable. They should have declared that the death penalty could not be carried out and referred the question of the substitute term. Now, we've cited a number of cases below, and then in those contexts, in the light of where the width of the constitutional provisions securing protection of fundamental rights are to be given a generous and purposive interpretation, restrictions on such protections are to be strictly and narrowly construed. Save for the reference to Section 14.3, there is nothing in the text limiting the jurisdiction of the court. And 14.3 just says you can decline in your discretion to grant remedy where there's an adequate means of redress elsewhere. This is not an adequate means of redress for the reasons that we've submitted. Then the powers of the executive to secure the applicant's constitutional rights by the exercise of mercy under Section 87 include substitution of a less severe form of punishment, and are not limited to substitution of a life sentence. There is no good reason why a limitation should be read into the remedial powers of the court under Section 14, where no such restrictions applies to the power of the executive. And then there is no binding authority to the effect that the court's powers under Section 14 are limited. And reading such a restriction into Section 14 deprives the court of its power to tailor the constitutional remedy to meet the individual circumstances of the case, even in the context of an appeal against sentence, where a death sentence is no longer enforceable because of delay. That was in the Ramdean gap, as it were, before the Privy Council reversed itself on the issue of whether you could do it. There was a determination, and the Court of Appeal said it's only the starting point in a case of delay. In the light of that, there's no good reason why a restriction, which does not appear on the face of the provision, should be read into the court's powers under Section 14, such that the court's ability to remedy a constitutional complaint is arbitrarily constrained. And we do cite Gary, where Chief Justice Byron said the provisions of Sections 16 and 101 of the Constitution confer unlimited jurisdiction on the court to fashion remedies to secure the enforcement of the fundamental rights and freedoms provisions of the Constitution and grant protection against the contravention of other provisions. And Lord Bingham, similarly, it is necessary to fashion a new remedy to give effective relief. And Lord Diplock in Maharaj was to like effect that it's not just the old remedies of judicial review, they can fashion new remedies. And then
I think it might be more appropriate to say cited without disapproval. I mean, the fact that he cited it, he doesn't actually comment on Chief Justice Byron's statement that the jurisdiction is unlimited, but he certainly doesn't disapprove it.
Yeah,
and
well,
I one assumes
my
that he
Lord,
approved it.
I mean, I could.
It was part of the argument, I think, or part of the recital of the issues.
Yes. Well.
But anyway, his own statement is probably good enough for you.
I'm obliged. My Lord, if I could take you on to paragraph 60. Further, as noted above, the Privy Council in Pratt held the power of, under Section 25 was sufficiently wide to enable the court to substitute for the sentence of death such order as it considers appropriate. Now, they didn't say the only person that can do this under the Constitution is the President. Yeah. They said we can do anything the President can do, we can do. Therefore, it must be right that the court can do it. And we submit, certainly if the court has a choice, it's utterly inconsistent with the separation of powers to say we'll send it back to the same bad old executive body that has made this series of, we respectfully submit, blunders in the way they've approached it. By just
the difficulty is in changing horses. The difficulty is that having one route having been operated, can you then operate the other route?
Well, my Lord, yeah, if the court has a discretion, what is the appropriate remedy? And they have a principle that wherever possible, the court should give effect to the principle of the separation of powers. Yeah. And moreover, should choose a more perfect rather than an imperfect remedy. It's very difficult to see how you could fairly and reasonably say, well, we've got a choice of doing it ourselves and acting in accordance with the most fundamental principles, or sending it back to the President. We submit. And moreover, my Lord, the reason we submit why in Pratt it was possible to say send it to the general observations about wholesale commutations to life was that at the time of Pratt, no argument was addressed and no consideration was given to the fact that it need not necessarily be a life sentence. And we've set out in the speaking there all the developments since Pratt. And they're pretty considerable. First being that you can give other sentences than life, as is now accepted. Therefore, there's a choice. The second being that where there's a choice penalty, it should be the executive, not the executive, but the judiciary that fixes it. And the third being that the starting point, which is the death penalty, is itself a cruel and unusual punishment, as my Lord Hughes held in Pittman and the board held in Matthew.
Or would be, but for the saving provision for...
Yes. Well, it is a cruel and unusual.
It is.
It is a cruel and unusual.
But it is saved.
But it is saved. Yeah. Matthew says, our starting point is it's a cruel and unusual punishment. My Lord Hughes, in his judgment in Pittman, says the starting point is that it's a cruel and unusual punishment.
Mandatory.
Yeah, mandatory imposition, yes.
Yeah.
But my lord, we submit that why are we even thinking in terms of the death penalty at all? It's because it was originally mandatorily imposed. I mean, how do we get the starting point in this case? It was because there was a mandatory imposition of the death penalty, which was a cruel and unusual punishment. And what's the best remedy then? It's to mend that very injustice. And so we then make the point that such a power was also exercised by Chief Justice Conte and Harris. If your lordships wish to see that, it's volume 2, tab 21, where where the appropriate, this was a case where it had been imposed on a mandatory basis, and also there had been a delay. And one sees at page 1626, in the light of this, I shall now address the appropriate remedy for the purpose of enforcing or securing the enforcement of Mr. Harris's constitutional rights. And then he sets aside the death penalty because it was mandatorily imposed and because of the delay. And then he makes the point at 1627, paragraph 33, I must say this is not necessarily axiomatic or automatic that the sentence of life imprisonment ought always to be imposed upon every convicted murderer who's not sentenced to death. And then he goes on to deal with the principles in Ray's. And at page 1629, halfway down, I therefore do not respectfully feel that Mr. Harris should receive a life sentence and leave the length of time he should serve to be determined by the Governor-General. And then in conclusion, I'm satisfied, given the facts of this case and the circumstances of paragraph 35, page 1629, the fact that he spent 11 years on death row, the mandatory sentence was wrongly imposed, and then he substitutes a sentence of 20 years. And in the later case of Baptiste, there was a substitution, I think, of 25 years, and we've given the board that reference too. So that's at paragraph 63. And at paragraph 65, we say the importance of taking into account the individual circumstance of the case was recognised in Cornwall. And, my lord, that's the case where the Attorney General of Antigua took the initiative of referring back all those mandatorily sentenced to the courts so they could be resentenced.
But don't forget, it's helpful to you're clearly entitled to make the point that the alternative sentence, the just sentence on a case of murder need not necessarily be life. But these various jurisdictions all have quite differing regimes, don't they?
Well, actually, in Belize, it's laid down that life is the alternative.
Precisely.
But even though it was laid down that life was the alternative, it said in the exercise of constitutional remedy, you can substitute less because so I mean.
But what I actually meant was that we mustn't get too excited about the figures. Some Caribbean jurisdictions have parole systems, others don't. Yes.
No, they're all pretty. And I don't know of any that has parole. They all have reliance on the commutation process.
I think you'll find there may be some.
Yes, my lord. I don't know of any of the independent.
And some have reviews and others don't.
My lord, yes. I mean, the bottom line in every Caribbean jurisdiction on the Westminster model constitution is that you can always apply to the executive for reduction, but that's and some of them have reviews from time to time. But my lord, what we submit is that in the exercise of the discretion of the Court of Appeal, it was contrary to principle and wholly unreasonable not to accede to the request for it to be sent back for judicial determination. My lord, we've set out the grounds where we say it should be a judicial determination once there was a choice of remedy at 6.4 of the speaking note. And perhaps, my lord, Firstly, because the Minister of National Security is a politician and not a proper person to determine the appropriate sentences. Secondly, because the judiciary are better placed. Thirdly, because there's a powerful argument that individualised terms of far less magnitude were justified. We've given you the reasons in some cases. Fourthly, because the procedure of the courts is far fairer in that it guarantees oral hearing, reasoned judgment and a proper decision. And fifthly, because the courts have evolved principles of sentencing which will ensure that the exercise of fixing the appropriate are governed by accessible and established criteria. And finally, the executive has already shown itself to lack the necessary independence and sensitivity to meet...
I mean, this does slightly depend on whether one has a grasp of the up-to-date position, which we looked at the Court of Appeal, and it was not apparent to me that they necessarily were doing more than assume, as you are here, that 20 years ago represents the present day. Can you actually help us? Maybe Mr. Knox can in due course, but it does seem a bit inappropriate simply to assume that the position is necessarily precisely the same when there's been relevant authority in between.
Well, my Lord, Mr. Delzin is here and can address you, but I obviously discussed it with him, and I know that they don't have oral hearings before the advisory committee. They don't give reasons, and so far as I know that...
I mean, it's rather difficult for us, isn't it, for us to rule on these matters without the views of either court in the jurisdiction.
They selected...
In this particular case?
Yes. My Lord, it appears that the reason that they did that was that they thought that if the... certainly in Mr. Justice Barrow's judgment, it appears, was he thought that if they went down the remedy of quashing and sending it to the judiciary, that somehow the death penalty would then stand, and that's why he sent it back to the president. But my Lord, we do respectfully submit that if one considers what are the alternative remedies, then as a matter of principle, if there is a choice, it should be the court itself determining, as has happened in countless other cases. My Lords, the only other point I would make is that in Cord, admittedly, it was after the mandatory death penalty had been set aside, but can I take you to that? It's at volume 6, at tab. It was cited at great length in the court below, but volume 6 at tab 3. There the death penalty had been imposed mandatorily on the...
What does volume 6, tab 3 start with? Is it the criminal appeal judgments? Is that the one?
No, my Lord, it's supplementary authority bundle. I hope your Lordship has it marked as 6, because we got...
Oh, I see. Ah, thank you.
You should have.
Right.
Yes. My Lord, it was because it was cited at some length below that we felt it right that the court should see it.
Right.
Your Lordships will see at page 57, their Lordships therefore return to the main submission, namely the mandatory sentence of death was unconstitutional. Mr. Dingerman's appearing for the Attorney General of Grenada did not contest this point. It was so held in relation to the similar constitutions of other Caribbeans in Rays, etc. The last case decides upon the true construction of the Grenadian constitution.
So this is one of the jurisdictions where there's no existing laws say that.
Yes, my Lord, that's absolutely right. And one can see, so that's, but perhaps just if we can look at it, if we go back to paragraph 8 at page 51, the Governor-General signed warrants in respect, which was cited, the Minister had decided to advise the Governor-General to commute the sentences. So there had been commutation, and the argument was to leave the commutation and allow the person to simply exercise his right to ask for lesser commutations. Mr. Dingerman submitted, however, the validity of the sentence of death was just as much raised judicata as the validity of the conviction. And then the appellants are no longer in the judicial system, and their only remedy is to petition the Governor-General under Section 60 to grant them executive clemency or refer their cases back to the Court of Appeal. And then he says that that has logic, but then at the end of paragraph 20, in practice, however, as was shown by the citation by Lord Bingham in Bow of earlier cases, it is unrealistic to expect that the argument which succeeded in Bow would have been entertained, let alone succeeded, before the Court of Appeal. Paragraph 29, secondly, the sentence in question was death. If the appellants were still at risk of execution, there can be little doubt that the board would not allow the principle of res judicata to stand in the way of granting relief to prevent the carrying into effect of an unlawful sentence. But the validity of the life sentence substituted by the warrant of commutation is dependent upon the validity of the sentence of death. In the absence of such a sentence, the Governor-General has no power to order that the appellants be imprisoned for life, and the appellants therefore remain held in detention without lawful authority. That's his second point. But then if we move on to his more broad points, which don't depend on the unconstitutionality of the mandatory death penalty. Thirdly, there has never been any judicial contribution to determining the sentences which the appellants should serve. Mr. Justice Byron, correctly applying the law as it was understood, exercised no discretion, and the appellant's present detention is solely by authority of the executive. Fourthly, there appears to be no adequate mechanism in Grenada for providing the appellants even now with the judicial sentencing procedure to which they were entitled. The only prospect of a review of the sentence is by means of the exercise of the royal prerogative of mercy, which depends entirely upon the executive discretion. It is the Minister who advises the Governor-General on the exercise of the prerogative powers in section 72(1) of the Constitution. Before doing so, the Minister may, if he so chooses, seek the advice of the advisory committee under section 74(2). And then at the bottom, there haven't been any reviews, it says. And then fifthly, and most importantly, is the highly unusual circumstances. For obvious reason, the question of the appellant's fate is so politically charged that it's hardly reasonable to expect any government of Grenada to take an objective view of the matter. Now, my Lord, we do submit that in these cases, and indeed generally in the cases of murders committed in Trinidad, if the matter is referred back to the executive, the question of the substitution will be a highly charged issue if the determinant, the people who decide the issue, is the Minister of National Security, acting on the advice of the DPP and the Attorney General and 4 unnamed others. There is a real risk again that there will be a political decision taken rather than an appropriate judicial decision. If you've got a choice, we respectfully submit that then the appropriate choice is to remit the matter to the High Court to determine the appropriate period. That's our submission. And we, at 6.6, we recognise that in the case of Pittman, the board held that the recourse to the powers of the presidential pardon is a proper avenue for the enforcement of legal rights. But in that case, the issue was the residual protection of a mentally disordered person from execution, where he has not succeeded in the making out a case of diminished responsibility at trial or on appeal.
Not so much where he's not succeeded, but where he hasn't advanced it.
Yes. Well, as I understand it, my Lord, your Lordship's judgment envisages 2 situations. One where there's some residual diminished, some residual mental problem which doesn't come within diminished or isn't enough. And 2 where it supervenes, and those are the 2 situations.
I say no more.
But it's obviously a totally different situation than the one that we have here. My Lord, it's at paragraph 50. I'm just trying to locate my volume 4, yes. At tab 41, Pittman, and one can see there at page 2431, paragraph 50, what about these defendants who cannot discharge the burden of proving diminished responsibility, but who nonetheless suffer from significant mental abnormality, or those defendants, or whose mental condition may have significantly deteriorated since the commission of the crime? Given the death penalty itself is a cruel and unusual penalty, which should be reserved for the worst cases, the board considers that it follows from the introduction of the partial defence of diminished responsibility that to carry out the death penalty on persons whose mental conditions meets the level required for that defence cannot now be constitutionally justified. Whether a person's mental functioning is significantly impaired will be a question of fact, but the Constitution is capable of accommodating such cases through the exercise of the prerogative of mercy. And of course, our submission was it would be a matter of law for, but we didn't emphasise the point about taking a constitutional motion to set aside the death. That wasn't the choice. The choice was whether you could read it into the provisions laying down the mandatory death penalty. In the opinion of the board, the existence of independent judicial control over the process provides sufficient constitutional safeguards for the cases under consideration. It's axiomatic that there is no systematic unconstitutionality where existing processes are capable of providing sufficient constitutional safeguards. Well, we respectfully submit that here it's not been shown and cannot be shown that the existing processes provide sufficient constitutional safeguard. My Lord, of course, the one thing that wasn't considered in Pitman is if you have a straight choice in a case of supervening illness between a constitutional motion to set aside the death penalty because the carrying out of the death penalty because the person is so disordered on the Ford and Wainwright approach in the United States. And that's the choice between that and going to the President or the Governor-General in that case. What would be the appropriate remedy? And our submission is the constitutional motion remedy must always be the prior one, because that is a direct determination by the court of an issue of legal rights. And our submission is that that therefore is the appropriate remedy. Well, therefore, that's the submission we make in relation to the remedy. And we say it was unreasonable and contrary to principle once the commutation had to be set aside to do it by way of a reference back to the very body that had given rise to the injustice. My Lords, that then you have at part 7 of the speaking note from page 36 onwards the alternative challenge to the Chief Justice's recording of the substitute terms. I've dealt with that point, my Lords, and we just commend that the 7.3, it submitted that the extensive powers of modification, which we deal with in the case, by construction are wide enough to confer on the Chief Justice the power to fix the appropriate substitute term himself, or at least to review the merits of any prison terms indicated by the President where they appear to be disproportionate or arbitrarily determined, which is obviously what we submit is this case. My Lords, those are the matters in relation to the fixing of the term. And the final point is about the sentences constituting cruel and unusual punishment because of the absence of proper review of the merits of continued detention. And, my Lord, that is set out in the case, but I would respectfully invite you to take this from the speaking note. We refer the court to the appellant's arguments as the cruel and unusual nature of the punishments inflicted on the appellants for the reasons set out in part 3 of the case. At present, the judgment of the Court of Appeal upholds the power of the President, acting on the advice of the Minister, to impose sentences of life, treated as the equivalent to sentences of imprisonment for natural life, and sentences of as long as 75 years. And the relevant rulings are at paragraphs 66 and 67 in respect of life sentences, and paragraph 79 in respect of the sentences to 75 years imprisonment. It's our submission that such sentences violate the prohibition on cruel and unusual punishment because of the absence of an adequate review mechanism under the existing procedural regime that governs the execution of such sentences in Trinidad. Now,
sorry, you mentioned part 3 of the case. We're just to take that from the case as read, are we?
Yes.
No, I'm quite happy.
Yes.
I just wanted, so we moved past part 3 to well, is it your speaking note, paragraph 7 now?
Yeah, yes, my lord. This is part 8, my lord.
Yes, I'm on 8.3. I see where we are, but
Yes.
I was just trying to relate the two documents. But
Well, my lord, all this is a slight amplification for the purposes of oral argument of the points that I put there. I mean, I suppose I could not hand in the speaking note and just read it out, but I hope it's better to...
We're proceeding as we are. I'm just trying to see where I got to.
My lords, so my page 39 then. In this respect, the appellants invite the court to adopt as a starting point the approach of the European Court of Human Rights. And that's because the European Court has laid down principles as to the necessary review procedure to ensure that a life sentence accords with the requirements of Article 3. Those principles have evolved from the earlier decision in Kafkaris to Vinter and subsequent cases. And the decision in Vinter has influenced courts throughout the world, including the Supreme Court of Zimbabwe in the case of Makoni. Can I just give your lordships the references? Makoni, volume 3, tab 33. Can I just perhaps give the court the references and that I commend? Pages 1948, 1953, 1954, and 1966. And what they said, that there must be they actually order that there must be a parole board instituted in exercise of their wide powers of constitutional remedy. But it also accords with the approach of Lord Bingham in the House of Lords in the case of Lichniak, which is in the supplementary authority bundle at pages 114, tabs 6. So, my lords, Lichniak is in the first of the, so tab volume 6. And it is, in our respectful submission, a helpful starting point. And it's, so, volume 6, tab 6. And at paragraph 8, page 149, Lord Bingham states, if the House had concluded that on the imposition of a mandatory life sentence for murder, the convicted murderer forfeited his liberty to the state for the rest of his days, to remain in custody until, if ever, the Home Secretary concluded that the public interest would be better served by his release than by his continued detention, I would have little doubt that such a sentence would be found to violate Articles 3 and 5 of the European Convention on Human Rights as being arbitrary and disproportionate. But Anderson, following earlier authority, makes plain that such is not the effect of such a sentence, and then he goes on. But it's the first part. What he's saying is, if the sentence is one of, you'll spend the rest of your life in custody, unless the penalty is remitted by an exercise of the executive in the widest discretion, then that violates Article 3. And that's precisely the situation in Trinidad at present. If you're given life, the only statutory provision is in the Constitution itself, and the Constitution gives the power to remit a penalty, but entirely unguided by any criteria. It's in the pure exercise of discretion. And there is no system for the determination of all those vastly different cases which are before, receive a mandatory sentence, or in this case, the commuted life term. They all get commuted life, in this case, these 47 people, and thereafter there's authority to detain them for the rest of their life unless the President commutes. And we would submit that does constitute a cruel and unusual punishment or inhuman punishment. It was only because there was a system for the determination of the appropriate punitive period in the individual case by the judiciary as a result of Anderson, and for a post-tariff review of dangerousness by the parole board that Lord Bingham said the mandatory imposition of the life sentence escaped condemnation as Article 3 inhuman. Now, if in these cases life has been imposed, as the court has seen, all of them received life, or if any of them receive life thereafter, and there is no exercise of reviewing those cases after some finite period within the life sentence, and there is no determination of when the point has been reached where they've served enough punishment and only dangerousness will suffice, and indeed no system at all, then we submit that on the Power and Lichniak test, it's inhuman punishment to give a life sentence. You've got to have a system for the mitigation, for the review of the penalty, which really does justice to the merits of individual cases.
Same reasoning would presumably apply to a determinate sentence, at any rate beyond a certain length.
Yes, I'd say.
What would the certain length be?
Well, where it's my lord, I'd certainly say in the 75 years in these cases would qualify, my lord.
Well, yes, but you're asking us to accept a principle which requires us to consider how that principle would apply in a variety of situations, one of which is, for example, a sentence of, say, 20 years.
Well,
would that be cruel and unusual if the process of review was purely administrative?
my lord, can I start from the proposition? If a judge has given the person 20 years, then the judge has determined, considering all his individual circumstances, that the person deserves 20 years. So your starting point is
Let's suppose that the President had done that by way of the exercise of his the prerogative of mercy, but had gone through a similar exercise. In other words, he had fully performed his obligation to listen to representations and so on. Would the position be different?
Well, then, my lord, the only point would be the point that there has to come, even where someone has been given a whole life tariff, as it were, as to the deserved penalty, there has to be some system of review, and that's the...
When you say some system of review, you mean a non-administrative system?
Well, I would submit that, my lord, yes. But
even a parole board, which is essentially an administrative function, wouldn't be good enough.
Not for the review of the case at a certain point, my lord, where the penalty is so long as to be tantamount to a life sentence.
So this is a principle that only applies to sentences which, essentially, having regard to the age of the defendant, are life sentences.
Yes, my lord, that's right.
So it wouldn't apply to a 20-year sentence unless the accused was 65, say.
Well, my lord, that might well be the case. That it's only if it's tantamount to a life sentence, my lord, yes.
Why is that? I mean, why is the system of the existence of a system of review more important in the case of a life sentence than it is in the case of a long but less than life sentence?
Well, I'm sorry, I'm going to give a simplistic answer because the courts have said so, first of all. But, my lord, what I would submit is, if there has been, first of all, a principled determination of the appropriate penalty, then the person can't complain. You've at no stage have you given individualised consideration to my case. And the vice of the life sentence is that it simply, as it were, hands over to the executive how long the person will serve. My lord, the second point I'd make is, if one's then dealing instead with a situation where the court, in the exercise of its discretion, has decided this person deserves lifelong punitive detention, the whole life tariff type case, cases of extreme gravity or heinousness, then I submit that the Vinter principles apply. And, my Lord, what the European Court of Human Rights, drawing on the Rome Statute and countless international covenants, has suggested is that if you should not go more than 25 years without a review of the length, of the justification for your continued detention. So one can really work it out. If you shouldn't go more than 25 years, it would mean that if the sentence was 40 years or more, you ought to have a review at some point in your detention. And that's drawing on a whole series of...
A review by a judicial body.
My Lord, can I try to take...
Different stages.
What the European Court says is there should be a review on the merits by somebody, and because of the margin of appreciation, they're not going to tell the individual countries how that should be done. But I would respectfully submit, yes, that in a constitution such as Trinidad, based on the separation of powers, it should be after 25 years by the judiciary. In other words, however long the sentence is, that you shouldn't go more than 25 years without a review of the merits of continuing detention.
By the judiciary?
Yes. But
those last three words are adding something to the jurisprudence of
I accept, no, my Lord, I accept that. What the European courts, although they're moving towards it should be by the judiciary, they have at present said that provided there is a mechanism for the review, they don't say 25 years prescriptively, but they indicate it's about that point. They've permitted 30 years in one case, but not permitted 40.
I mean, I don't quite see what's special about Trinidad, where they don't benefit from the margin of appreciation.
Oh, because you are the court. You are the court. There's no margin of appreciation here. You are the Trinidad Court of...
But we're talking about the adequacy of the system of review.
No, my Lord. We're talking about whether you leave it to the individual national authority, because you are the European Court of Human Rights, which has to leave it on principles of respect for the different systems, leave it to the individual systems, or whether you are the Trinidad Supreme Court. In other words, our Supreme Court could go far further in laying down minimum requirements.
I quite see that we could, but I mean, what I'd like to know is why should we? Why should we conclude that the system is inadequate in a way that cannot be sufficiently dealt with by the powers of challenge that exists as a matter of public law anyway?
You mean an administrative review subject to judicial review?
Exactly.
Yes. Well, my Lord, I submit, because if there comes a point at which the question must be asked, which on the European Court's jurisprudence it must be asked, is there a continued penological justification for detention? That issue is an issue which should be resolved by the judiciary rather than the executive.
Not just in Trinidad, but generally.
Yes. Yeah. My Lord, yes. And it's only, my submission is only because, I mean, for example, under the Rome Statute, these are people convicted of the most appalling crimes against humanity. So where it might be well thought, well, they do deserve the whole life in custody, it's said there must be a judicial redetermination after 25 years of whether the continued detention is justified. So that's the reason why we make that submission.
So the parole board wouldn't be good enough in Trinidad and Tobago?
Well, it would if it's I mean, the parole board has been found by the European Court and indeed by our courts to be sufficiently independent of the executive to satisfy the requirement.
Yes, but it's not judiciary.
Well, my Lord, it's sufficiently judicial to be an independent body exercising. I mean,
It's not the separation of powers as we know it from Hines and Leonardi and so on. It's not that sort of.
No, I see. No, it's got to be an.
It's just that there are some features of judicial activities which also apply to administrative ones. For example, rules of natural justice and so on.
No, my lord. Well, sorry, I'm so sorry.
That doesn't make it a judicial process. What makes it acceptable, surely, is that although it's an administrative process, it is one, independent, two, required to observe the rules of natural justice, and three, critically, subject to judicial review by the courts if they step outside the limits provided for by public law.
Well, my lord, what the European Court jurisprudence says is it's got to be a body independent of the executive.
But I think a moment ago you were telling us we shouldn't take account of the European jurisprudence in this context because it's based on the margin of appreciation. If we do, then we apply a concept of independence, which would be met by a body like the Parole Board.
Oh yes, my lord, I certainly would submit that the Parole Board is sufficiently independent of the executive to satisfy the requirements of an of a review by a body independent of the executive.
I see.
And my lord, there is authority for that, and they don't rely on the margin of appreciation. I mean...
Right, so no, that clarifies it. I mean, I think we were a bit confused, at least I was, by your distinction, your separation of powers point, which is a slightly different point. Because
yes,
that looks at the judiciary in a very traditional...
Yes, I see, my lord. Well, I certainly could modify that proposition. My lord, what we say is there's got to be a review after 25 years at the very latest.
But not by this sort of body that they have.
No, because it is the executive. It's not independent of the executive. It's the Attorney General, the National Security Minister, the DPP, the people who are all trying to hang him, and then four other people we don't know who they are.
Mr. Fitzgerald, we shall look forward to
continuing.
Okay, You're on course, I think.
Yes, ma'am. Yeah.
Thank you very much. 2 o'clock.